Hey there, everybody. Your estate life and estate planning coach, Spencer Sen here. If you want to know how to connect with me, go to www.spencersen.com and you can find out all the different ways to connect. My private and free group, Instagram, Twitter, all that stuff. Or if you want to just email me. But anyhow, I wanted to talk today a little bit about wills. Unbelievably, over 85% of people think a will protects them or helps them in some way achieve what is important to them. And once people learn what a will does, for example, think of a will as a wish list. And a will, if you have a home or more in assets, real estate or more in assets, you're going to be subject with that will or without a will to go through, your family's going to go through probate process. It's a law. In Wisconsin, it's 50,000. Illinois, it's 100. Florida, 75. The threshold is different in every state, but the process is the same. And a will is a wish list until it goes through that process, and at the end of it, the judge deems it valid or not. And unfortunately, the judge gets to say control and say all. Okay? So it's very important that people understand this. Most people don't. Okay? They assume they know, but they don't. All right. So then I've had a lot of people, different people through my group and appointments and different things ask me what happens with a will when you move to a different state. Okay. First of all, each state has to recognize a will. All right. But what I first recommend is the first steps when you move to a different state is have your estate plan reviewed, whether it's a will and power of attorneys or more. There's all different kinds of documents. Most people never have all what they need. Okay, but have an estate plan reviewed and updated to meet the requirements of the new state. Okay, there will be different requirements. And then if you have a trust, a revocable living trust, one still needs to have updates and things done, even though it's a federally recognized document plan in every state. Powers of attorney and advance directives are state specific. Okay, so most people I find have a will and maybe power of attorney. Power of attorney is state specific. So if you move from Wisconsin to Illinois, your Wisconsin power of attorneys are no good. You have to go get new ones, and also the advance directive. Okay, a judge may decline to probate an out-of-state will, where you get into bigger issues. Okay, and once that happens, if they decline to use your will, it's called dying intestate, where it's the quickest way to process your estate, but it's the most expensive. They do whatever they want then. Okay, so a will that's drafted and executed in one state is valid in another state under what's called the full faith and credit clause of the U.S. Constitution. Okay, but states have very different requirements for a valid will. All right, states also have a different approach to interpreting wills. A probate judge, for example, may decline to admit an out-of-state will to probate. Now you're in intestate, which is worse than if you had the will. Okay, and if there's a conflict, the law of probate in that state, it will be used. Okay, so it's important to know these things. Reasons a valid will is not fully enforced in other states. Impact of change in a marital status, post-signing birth of a child, okay, events that happen after the will was created, out-of-state personal representatives, if people live out of states, other places that don't live in the state where the will is. So there's all kinds of different things that come into play here, guys. And I see on a daily basis people just assume they have what they need in place and they don't. But that's also because nobody's teaching it like what I'm covering here. All right, and then moving from a common law state to a community property state, that's even worse because you have completely different laws and rules that you have to follow and things to address. Property ownership and asset distribution for married couples completely get handled differently. All right. And then what about moving to a community property state, moving from a common law state to a community property state, like community property state, Louisiana, Texas, Wisconsin. Property ownership and asset distribution are handled completely differently. The laws are different. A will from a common law state is basically likely to be challenged or invalidated by anybody, but first and foremost by the judge. Okay, and then reasons a valid will is not fully enforced in a different state. A continuation of that, states are expected to honor wills signed in other states, like we talked about. Different requirements for numerous issues. The judge may decline to probate the will entirely or substitute the statutory default in that state. The locations of signatures, who can act as witnesses. The impact of an improper witness also varies, okay, state to state. Requirements for a will to be self-proving, steps required to disinherit a child. All of these are things that are different in different states, okay, and can affect whether they accept it or not. And then for power of attorney documents and advance directives, like I stated in the beginning, they are very state-specific documents. So one in one state is not valid in another state. So if you move, you've got to get new power of attorneys and an advance directive. If you live 6 months out of the year in one place, 6 months out of the year in the other place, you need two sets. Hopefully that makes sense. But again, you can connect with me if you want to talk further about that. It's highly unlikely that a financial institution will accept an out-of-state power of attorney finance. Okay? It's not going to happen, guys. So be prepared. Healthcare providers will not likely accept an advance directive either. Okay? So you get to that unwanted life event and find out, oh, my advance directive is no good. So guys, keep this short, sweet. You know, if first of all, a will is a wish list. That's going to require probate to be probated if you own a home or more. Each state has a dollar amount or threshold, they call it. You go over that. Now, there are tools or band-aids that you can get around that and do other things like transfer on death or quit claim kids to your deed, but there are other risks. Those are not considered estate planning tools as standalone tools. There are other variables. A trust is the only general tool that prevents probate, and done right, nothing can contest it or end up in court or anything. It privatizes your affairs and protects them properly. So a will, most people think a will protects or helps in some way. It's going to cause the surviving family to go through probate. Okay? There's variables, there's risks. The court and the judge has a full say over everything. It's lengthy, it gets costly, all kinds of variables. So guys, hopefully this message helped. Please reach out to me if you would like to discuss this further, or I have affordable ways that you can achieve the right documents and learn what you need and get them in place properly. Have a great day. And remember, having a plan in place is literally the greatest gift that you can provide your family, because you're prepared, you're privatizing everything, and you're controlling what happens and help them navigate through those unwanted life events. Have a great day. Look for more information and content from me here in the future.